Hi everybody, this is attorney Arkady Frekhtman. I'm a New York City personal injury trial attorney, and today we're doing a case analysis. And it's an interesting case. It's actually a New York case. It was a verdict that happened in December of 2022, fairly recent, about a few months ago. And it's a large verdict, and it's a difficult case. A case that a lot of plaintiffs' attorneys and maybe people too would think had a very high verdict for what it was. So let's talk about it. Basically, it was a trip and fall in the Bronx, and it resulted in a verdict finding the defendant to be 100% at fault and also allowing for many millions of dollars in damages. The total was $10 million. How did they do it? Well, it involved a 71-year-old woman who suffered a hip fracture that required an immediate open reduction internal fixation surgery. So that basically means there was a hip fracture, and this fracture was so bad that they had to do an open reduction with internal fixation. That usually means plates and screws to hold the fracture site together. The surgery actually failed, and then she had what's known as a non-union or a malunion. That basically means that there's no union between the bones, and the bones are going in different angles. And so a few months later, she needed a total hip replacement. So not just plates and screws, but an entire hip replacement surgery. And then a year and a half later, the other hip gave out. And so she underwent a replacement of the other hip. And then she added that to the case as a secondary or consequential injury, meaning that injury is because of or as a consequence of this fall. And so she adds that to the case. And she claimed that the original hip injury, fracture, exacerbated a pre-existing incontinence condition, which she had before. And the liability, he doesn't even I'm going off a description that he provided in one of the trial attorney groups, but he doesn't really even talk about the liability. He just says it's a fairly typical trip and fall. So probably there was like a raised sidewalk or there was a hole in terms of the negligence. And he says that on damages, the only unique or unusual aspect was the incontinence claim, because that's something a little bit different, and the causation, whether it was caused by this fall or whether it was a pre-existing condition or aggravation. So they had some disputes about that. And he felt like the big issue and the big defense in the case was that his client at the time of the incident was 71 years old and had a long, extensive, and detailed prior medical history of everything under the sun. She had arthritis in her feet, her ankles, her knees, her neck and back. She had neuropathy, polyneuropathy, incontinence, nocturia, chronic fatigue, chronic pain syndrome, radiculopathy. This was all stuff she had before, right? Not because of this, just stuff she had before. And in fact, before she ever fell, she applied for an accessoride because she couldn't get around. And on the application, she complained about everything and literally said just my entire body, and she couldn't manage public transportation on her own, like taking the bus or subway. So she needed this accessoride, which is like a car, a nice big van, picks you up and transports you. So basically that was the case. And so the lawyer was tasked with this difficult task of now, going into court with this 71. She was 71 at the time of the fall, of the incident, of the injury. She was 76 at the time of the trial. So this lawyer had this difficult task of going in there and getting many millions of dollars for somebody that was already so vulnerable and so injured, right? Because this is degenerative, meaning it's from living your life. It's not from the fall. But of course, the fall and the injuries from the fall, like the total hip replacements, they don't make it any better, right? If you do that to someone, if you add a total hip replacement and bilateral both hips to someone who's like really strong and an Olympic athlete, okay, they're going to be able to somehow overcome it, maybe go back to sports. But if you give that injury to somebody like this who's already injured in their entire body, then they may not be able to recover, right? That might be a life-changing forever injury. And so the lawyer said that this went to the heart of his claim for loss of enjoyment of life, the claim of physical limitations, the ability to do the activities of daily living, the functional capacity, things like that. And it struck at the heart of also his life care plan, which centered on the need for a home health aide. So this is what he did during trial. In voir dire, he basically used this concept of brutal honesty. He said, look, let's talk about brutal honesty. I want to be honest with you. And I think it should be reciprocal. I'm going to be honest with you about my case. So he basically just was honest, and he said, look, this is the truth. This is who she was before. He didn't like just hide. A lot of lawyers will hide all these issues, right? I don't want this to come up. But what's going to happen if you hide it, right? The defense is going to bring it up for the first time. And then the jury is going to look at you and say, wait a minute, why didn't you tell me about any of this? And you're going to get really, really hurt by doing that. So his approach is very smart. He brought it up, he fronted all the issues, and he said it's reciprocal, so that the plaintiff is going to be brutally honest about and then he also attacked the defense, because he said the defense is making arguments and presenting evidence that is not brutally honest. And he spoke to the jury after the verdict came in, and a few of them, in fact, several of them, mentioned brutal honesty. And they said that concept really resonated with them and helped them get over the client's substantial prior history. So the other thing he did was he was very, very aggressive, very direct, and about just admitting, embracing, and framing all of the case weaknesses right at the outset. So he talked about the case weaknesses and problems in jury selection, as well as probably an opening statement. But he didn't just mention them and move on. What he did is, throughout opening and the entire case, he weaved the weaknesses into his case story and themes, and he made them, and he used proper context for them, and he made these weaknesses central to his prosecution of the case. So I think that's really important too, because, you have these weaknesses, but he weaved them in, and he kept referring to them in a way that they're part of his overall story. That's very smart. He doesn't exactly, give specific examples of how he did it, but it kind of makes me think, I kind of did that a little bit in my last trial, where we got a $500,000 verdict. And one of the weaknesses I had was that I only had 4 visits to the hospital, basically, not a lot of medical treatment. And I kind of explained that the reason was because she was a girl at the time. She was a kid. She was 13. She couldn't go to the hospital on her own. She needed a father or a mother to do that for her, but she didn't have that because the mother maybe was out, working, or out seeing boyfriends. The father was divorced. He was a former alcoholic. He wasn't in the home. So she was almost abandoned by herself. And you can't expect a 12-year-old to go and, navigate insurance and make appointments and go see doctors on her own. And the jury really understood that. So it's good to think about your case and think about how you're going to deal with issues, but also good to front the issues and just be brutally honest and be vulnerable. So yeah, he said that before the pandemic, he didn't do it this way, that he did it more like the old school way, and he sees that this is a better way. And he says you gain credibility, you neutralize the defense arguments and innuendos, because that's what they really are, right? They're innuendos. They're they're not saying you're a liar, cheater, and a fraud, but they're alluding to it. That's what the defense likes to do. So, and then you show the jury that you are meeting the promise of brutal honesty, and also you're capturing the moral high ground. So the first 2 things he's talked about the case in jury selection were, number 1, he said, this woman had a ton of problems beforehand. So he fronted that, right? But he said this incident made her situation a lot worse. And it makes sense. And it's a trauma she was not prepared for. She was more susceptible to the injury. So that's number 1. Number 2, he said that we saw the liability part of the case as a shared responsibility situation. So even though, let's say there was, he doesn't even say what it was, but I'm just guessing, let's say it's a hole or a raised sidewalk, raised crack, some kind of unsafe condition. Instead of saying, no, the unsafe condition is all because of the defendant, he was honest and he said, look, it's a shared responsibility. You had this unsafe condition, maybe it was like a raised sidewalk, shouldn't have been there. You're responsible for that. And my client, she'll look in the mirror and she'll take responsibility for her actions. Perhaps she should have, she could have seen that raised sidewalk and not stepped in it. So he's saying it's a shared responsibility right away. And by doing that, he's basically saying that the plaintiff is willing to accept her portion of responsibility, that she's taking ownership of it, and she's willing to be held accountable. And guess what happened? Because he did that, the jury ultimately came back with zero comparative. They did not want to blame the plaintiff at all, the 76-year-old lady, because she was willing to accept responsibility. So that's a really, really important point. And third, from the beginning of the trial through summation, the plaintiff's attorney tried to polarize the case by slamming the defendant for denying responsibility for the incident, for refusing to take even a little responsibility. See, the defendant was doing it the old school way. They were like, no, we're not at fault at all, it's not us, even though they have this, whatever it was, like a raised sidewalk or a hole, and they just refuse, they don't want, that's what a lot of the time they love to do. They like to take the scorched earth approach, right? Polarize the case, meaning like, look, which one is it, right? Is she just an honest old lady who was walking and who tripped and fell because of an unsafe condition, and now she's coming in here for reasonable compensation? Or is she some kind of liar, cheater, and fraud, which is what they want you to believe, that they're not at fault, even though they have this, condition. Look at it, it's a hole, they have it, but they're not at fault for it. And then this person is somehow trying to, create or concoct a false case just to make money. And basically they're calling her a liar, a cheater, and a fraud. So that's what he did. And he said, look, they're refusing to take even a little responsibility, and they're blaming my client for everything, including on damages. They're blaming her for her age. They're blaming her for her infirmities, her gender, right? Because of the incontinence. And then he says, even though they were not calling her a liar in the case, which is the traditional polarizing context, they were going for the win on liability and damages by blaming her for everything, which allowed him to then characterize their position as unfair, unjust, and motivated by the desire to avoid paying for the harm they caused. And he said, given that the defense was largely based on age-related degenerative conditions, I really attacked them with the notion that they were peddling unequal justice for the elderly, right? Because let's say, if that client was 20 years old, they couldn't say that, right? They would have to say, look, whatever injury, hip replacement or broken arm, whatever the injury was, they couldn't make this argument. But the only reason they're making it is because she's 76. So they're saying this isn't from our unsafe condition. This is just from living her life. And then we had nothing to do with it, right? They don't want to take any responsibility either on the issue of liability, that they were at fault, or on the issue of damages, that they caused any additional harm to this already, sick woman, sick older woman. And also the idea that these were her golden years, right? Because if she's 71 when it happens, she doesn't have that much time left, right? On average, what people maybe live to be 80, maybe 80, 83, 84, statistically, women. So she had maybe a decade left. These are her golden years. Does she want to enjoy her golden years? Or does she want this double hip replacement and horrible surgery with open reduction, internal fixation, plates, screws, all of these 3 surgeries added on top of everything she already has, right? And that's basically taking away her golden years. Because when you are 20, you feel like you're invincible, right? You feel like you have forever. But when you're 80, those are your golden years, and each moment, each second is really, truly priceless, because that's the last one you're going to have. So that's a good point that he made. And he basically said that's an unequal justice for the elderly. And he said, by their logic, if you follow the defendant's logic, then the courthouse doors are basically closed to anyone over a certain age. That, if you're over a certain age, if you're over 70, you just can't come to the courthouse. You can't get justice. And so that was a really powerful argument. And he said that they were abusing the issue to avoid their own accountability. And so speaking to the jury after the trial, he said these arguments worked and they looked past her pre-existing injuries and reacted badly to the defendant's total denial of fault. So yeah, so I think this was an interesting case for these are a lot of the issues that, you know, I deal with when I try cases. And I think you see, like, by examining other cases, you get to learn that a lot of the issues happen over and over again, and you get to prepare for them, and it's very helpful. So let us know what you think. Please like and subscribe to our channel. Let us know what other videos you'd like to see, and we are here for you. Okay, have a great day, everyone. Thank you.